My Lords, the debate on this group of amendments has been invigorating and useful. I thank all those noble lords, and in particular the noble lady, the Minister, Baroness Jones, who have contributed to it. My noble friend, Lord Wolfson of Apsley Guise, commended the intention of the bill to counter ill effects of zero-hours contracts, which his company does not use. I honour his intent and indeed his extraordinary contributions to the nation's employment and its economy in general. I note that he tended to agree with my proposal overall in respect of the dysfunctionality of this clause. I'd be happy if the wording of the clause, if it were incorporated into the bill, to be in a way that incorporated his wording but removed the rest of this clause from the bill. The noble Lord Fox, who does not appear to be in his place, spoke to Amendment 4, an amendment that in the case that Clause 27BA is retained in the bill, switches the origination of a flexible hours discussion from employer to employee. Clearly, this is a more sound and flexible approach, though, of course, I can't go along with his later statement that he meant there to be an obligation on the employer to provide what the employee demanded. My noble friend, Baroness Lawler, spoke movingly on the many things this government has already done to depress economic activity, and said better than I how this clause would make things much worse. She added in the crucial point that the ill this clause purports to address is in fact a good, much preferred by the majority of those working flexible hours. My noble friend Baroness Verma spoke with the authority of one who has great experience as an employer. She implored the government to get its nose out of what should be a more relaxed and less formal relationship between employers and employees. The government should pay her heed. My noble friend Baroness Coffey spoke forensically about the wreckage this cause would create in the hospitality industry and also, very worryingly, in the NHS. Over and again, we heard noble lords speak about the need for flexibility. This clause creates the opposite. My noble friend Lord Sharp of Epsom pointed particularly to the appalling outcomes this clause will create on the numbers of youth unemployed. Earlier, my noble friend Baroness Mayer mentioned French youth unemployment at 19.2%. Has the government any clue how that occurred? They didn't intend that to happen, obviously. They don't want 1 in 5 of their youth unemployed who are seeking work. It occurred from precisely the sort of legislation that the government is proposing to introduce here. My lords, do we really want our youth unemployment to be 1 in 5 of those wanting to be employed? That, my lords, is what I mean by outcomes, rather than this notional and very generic idea of fairness, because it's not fair either. The noble Baroness, the Minister, confirmed that the reference period will be in the legislation. This is welcome news. But it would have been better were it in the draft legislation right now, so that we could debate it right now, the time that we are supposed to be debating it. The noble Minister showed an impressive ability to wade through the latest iteration of what is an extraordinarily complex proposed set of rules. But creating and explaining such rules misses the entire point. This government believes, quote, "We know best, and therefore if we create this perfect machine, these wonderful processes, then all will be well." They don't know best. The market knows best, and the market should be left to itself to sort out most of these matters. I urge the noble Minister to heed the words of the noble Lord Wolfson and the noble Baroness Verma to provide clarity as soon as possible and to provide flexibility in the way that they have just urged her. Noble Baroness, the Minister, sought to provide clarity on agency workers. With respect, her words did not reflect reality. Take, just as one random example, the interim management sector. These individuals take jobs to fill gaps that suddenly appear in a company, to fill the period before a permanent replacement can be found. The appointment of an interim manager may last a day or it may last a year, depending entirely on events that will only be happening in the future. To guarantee hours for these individuals is quite frankly impossible, just entirely impossible. And that's just one of many different sectors, different possible examples, as the noble Baroness Neville-Rolfe and the noble Baroness Verma made clear just now. I remain convinced, my lords, that the outcome of this clause, if passed into law, will be significantly less, not more, jobs. Having said which, there are, of course, other ways of improving this clause if it is not removed entirely. These ways, noble friends and the noble Lord Fox have offered with their own amendments. The vast majority, which I've indicated, I do agree with, not least from listening to the experienced voices of business from these benches. My lords, to conclude, the removal of flexibility from employers cannot possibly be a good thing. The more employment flexibility that is created in an economy, the more creative are the ways entrepreneurial employers find to grow the economy, to create more jobs, to improve living standards, and indeed to provide the government with more tax revenues to meet the depressingly larger and larger commitments that this government continues to take on. Having said all which, I reserve the right to bring this amendment back at the report stage, and in the meantime, my lords, I beg to withdraw.
Yeah.